Your Honor, the state also filed a response to this motion. The key words to pay attention to in count 10 are that if the personal watercraft is being operated by a child under 12 years of age, under the voting statutes, Your Honor, 69.9101 and 69.9505, that would put the adult passenger as criminally responsible for that minor child operator of watercraft. State argues that this is more of a factual issue, as the facts would show that the defendant was unable to take control of the vessel, which that's what the law requires when an adult is on the back of a PWC. And the facts would show that he was unable to do that, and that was the reckless conduct, Your Honor. So we charged it under criminal responsibility theory.
Go ahead. Clement, do you have anything further?
Yes, Your Honor. Part of what's going on here is that for someone to be criminally responsible for the conduct of another, would have to have some sort of mens rea, something going on in their mind and something going on in their actions that links their criminal conduct and is the same as the reckless conduct. Even if we were to grant that he was in some way negligent, then it still would not rise to the level necessary to be able to indict him for a reckless crime, as the state has attempted to do here. For that reason, I ask that Your Honor consider dismissed.
The indictment in count 10 alleges that the defendant was an adult passenger on a personal watercraft being operated by a child under 10 years of age. Tennessee Code Annotated 69.9505 states the following: it is unlawful for any person under 12 years of age to operate a personal watercraft upon the waters of the state of Tennessee unless such person is under the direct supervision of an adult. Direct supervision means being in such a proximity with an operator as to be able to take immediate control of the vessel. In reviewing the Tennessee Wildlife Resource Agency's investigation, their findings are that the defendant was not in a position where he could take control of the vehicle, and therefore he was in violation of that particular provision of the law. The count that we were talking about alleges that he engaged in reckless criminal conduct by being a passenger and allowing the child of under 12 to operate the motor vehicle or the watercraft rather, that collided with another. And I think that in the reading of the statute that the child was prohibited from driving it unless this individual was able to control it, and reading the facts as set forth in that investigation, this court is of the opinion that it does become a factual issue for the jury to determine whether or not he did it, whether his violation of that statute considered to be or would be considered to be such reckless criminal conduct as to render him liable for it. I think that is a factual nice. And the defense is free to renew its motion to dismiss following the trial of this case, so that my opinion is that the indictment is sufficient to put the defendant on notice of the charge and the basis for the charge, and it's a matter of factual basis whether the jury would find that there is a proof beyond a reasonable doubt that he is engaged in reckless criminal conduct. And I'm allowing the defense to renew this motion following the trial of this case to determine whether or not there is a basis for a dismissal. Okay. That is my ruling. Your last one is a motion for bond. Are you ready on that?
Yes, Your Honor.
And you have both a motion to set bond and a motion for individualized bond determination, which is basically an application of the bonding rules. Pretty much what I do in every case anyway. So
yes, Your Honor.
Any reason for a different hearing in that?
No, Your Honor. I would proceed as a normal bond hearing.
And I'm ready to hear it.
Your Honor, I would like to first offer as an exhibit the report of the Tennessee Wildlife Resources Agency,
yes,
which I previously provided.
You've given me a copy of it, and I have it here, so I'm going to provide that to the clerk.
And I would like to merely draw the court's attention to the facts as presented in there and the conclusions of law enforcement at the end, which conclude as far as any recommended charges, that they recommend that perhaps Mr. Felony might be charged as an accessory to the misdemeanor violations of allowing that and more. No such things as homicides or assaults is recommended by that report, nor I would say is strongly supported by the facts. The facts as set forth in the report are straightforward. Mr. Felony was one of two passengers riding along behind the operator of the personal watercraft, who was following along behind somebody else's personal watercraft. The one in front turned in front of the one being operated behind it, and the one behind it continued on straight, and they collided. If this were a civil trial, we would be throwing around terms like contributory negligence. We might look into whether the operator of the other watercraft had any responsibility for these actions. Of course, my client would be a potential plaintiff in such a suit, even being injured in the incident as well. But for our purposes, it's much more limited. He is being charged with criminally negligent homicide and reckless assault based on the theory of criminal responsibility for somebody else's reckless conduct. He is also co-defendant along with the child's father, who we would say is the one more responsible for making sure that the child is old enough to operate a watercraft and is wise enough to operate it in a non-reckless manner. I would also like to present as an exhibit, if I may, this is, let me pass this up, please, Your Honor. I have taken the liberty of getting a diversion eligibility certificate, and I would like to pass that forward for the purpose of demonstrating that my client has no prior significant criminal record and is facing, at this point, a Class E felony, and I believe a Class D felony at most, for which he would be eligible for a post-trial diversion even if we were to go to trial and lose. There is no intentional bad conduct alleged against my client. It is not clear from the report that he even knew the age of the person who was operating the watercraft, and I would think that may become significant as to what level of proof he had to show that he can say that he did anything wrong. His bond is I think $50,000 right now, and Your Honor has already, with the agreement of the state, seen fit to dismiss most of the 10 charges against or rather the 5 charges against the others were related to the other person. In consideration of all this, Your Honor, we ask that the bond be lowered and that he be allowed to make a more reasonable bond. We would suggest at most $10,000 for this case and allow him to be out of jail on a reasonable bond while awaiting this trial, which will take a few months to get put together.
All right. Anything other than arguments you wish, and these 2 exhibits that you wish to offer?
No, Your Honor.
State, have any proof you wish to offer or argument you wish to make?
No, we defer.